standing for the jury.
All right, everybody be seated, please. Good morning, folks. Thank you for being back here this morning. You've now been selected and sworn as a jury to try the case of State of Florida versus Henry Segura. As we've, of course, discussed, this is a criminal case. Mr. Segura is charged with 4 counts of first-degree murder. Later, during the course of the trial, I will explain to you the exact elements of those offenses. The charging document, the indictment in this case, is not evidence, and you should not consider it as any proof of guilt. It's my job to explain the law to you. It's your job to decide the facts of the case and to apply the facts to the law. Thus, we have totally separate jobs, and that's one of our fundamental principles of our system of justice. I decide the law, you decide the facts, you apply the facts to the law. I know all of you see trials from time to time on TV, but you probably don't see one from beginning to end, so it might be helpful if you understood the sequence of events. The next thing that will happen is the attorneys will be given an opportunity to make an opening statement. The opening statement gives the attorneys a chance to tell you what they believe the evidence will be presented during the trial. What the lawyers say is not evidence, and you're not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits also may be produced as evidence. After the evidence has been presented, I will instruct you on the law. The attorneys will then have an opportunity to make their closing arguments. Following the closing arguments by the attorneys and some brief comments by me, you'll retire to consider your verdict. You should not form any definite or fixed opinion on the merits of the case until you have heard all the evidence, the argument of the lawyers, and the instructions on the law that I will give you. Until that time, you are not to discuss the case among yourselves. Your verdict must be based solely on the evidence or lack of evidence and the law that I will explain to you. I now instruct you, you are not to communicate with anyone, including your fellow jurors, about this case. No communication includes no emailing, text messaging, tweeting, blogging, or any other form of communication. You cannot do research about the case or look up any information about the case. If you become aware of any violation of these rules at all, notify the court personnel. During the course of the trial, we will take recesses, and you will be permitted to separate and go about your personal affairs. During these recesses, you must not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about the case, tell them that you're on the jury trying the case and ask them to stop. If they persist, leave them at once and immediately report the matter to the bailiff, who will advise me. The case must be tried by you only on the evidence presented during the trial, in your presence and in the presence of the defendant, the attorneys, and myself. Jurors must not conduct any investigation of their own. This includes reading newspaper, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you're in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of a defendant to prove his innocence. from the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt, and the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had he or she been permitted to answer. If you would like to take notes during the trial, you're free to do so. On the other hand, you're not required to. That is entirely up to you. We've given you a notepad and a pen for your use if you wish to take notes. Any notes that you take will be for your personal use. However, you should not take them with you from the courtroom until you start your deliberations. During recesses, if you'll just leave your notes in your seat, the bailiff will ensure they are not tampered with by anyone. After you have completed your deliberations, the bailiff will destroy your notes. No one will ever read your notes. If you take notes, do not get so involved in note-taking that you become distracted from the proceedings. And you may wonder what I mean by that. We've had a rare instance where some juror decides to kind of act like a court reporter and write down everything that's said by all the witnesses. An important part of your job is to observe the witnesses, decide whether you think they're accurate historians or not. Don't get so buried in note-taking that you lose that function. Your notes should be used only as aids to your memory. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. During the trial, you will be permitted to ask questions of witnesses in case you missed something, you did not understand something, or you need to clarify a pertinent issue. The rules of evidence apply regardless of whether a question is asked by the attorneys, by me, or by you. Therefore, there may be a legal reason why I cannot ask your question. If I do not ask your question, you must not hold that against any of the parties, and please do not take it personally. Subject to that understanding, this is how we will proceed. When the attorneys have finished asking their questions, if you have a question, please raise your hand. I try to remember to stop and ask each time, but sometimes in my old age I forget. But we do it at the end of the questioning by the attorneys. We don't do it in the middle of the testimony, but at the end of the questioning, if you have a question, simply raise your hand. I will give you time to write your question on a clean piece of paper, and the bailiff will collect it. We don't do any questions by the jury verbally because I need to meet with the attorneys and discuss the question you've proposed. If I determine that it is a legally appropriate question, I will ask your question, and the attorneys may ask follow-up questions. If your question is not asked, you must not discuss it with other jurors or hold it against either party. The questioning of witnesses is the primary responsibility of the attorneys. You are not obligated to ask any questions, nor encouraged to ask large numbers of questions. However, if it will help your understanding of the case, you may do so. As I indicated, the next thing that's going to happen is the attorneys will be given an opportunity to make an opening statement. As I've also said, what the attorneys say is not evidence, and you should not consider it as such. However, I do encourage you to give them your careful attention. The opening statements are intended to give you an understanding of the evidence that the attorneys expect to present and the issues in the case.